All right. Peace. Greetings to you all. It's your brother Naheem, BKA Lord Abba, AKA Mr. Just Back. All right, family. You already know what time it is. Let me get Ali up to here. You already know what time it is, family. Shout out to Brother Dre. I love that comment, man. I got to put Brother Dre's comment up. He said, here for this. Another win for the hood guys. Hashtag Freedmen up. Another victory, fam. Providence. Y'all been hearing us say this for the longest. This work that we've been doing is so important. It's so important. I'm gonna cut the music off on this one. We ain't gonna let the music play on this one tonight. We just gonna go in tonight. Family, hit the like button, share the video out. If you are not subscribed to the channel, subscribe to the channel, become a part of the Notification Nation by hitting that little bell icon next to it so you'll be notified every time Be the Power goes live and we drop our dynamic content, because our content is dynamic. Peace to our sister Frida in the building. What's going on, sis? What is going on? So yeah, man, you're up. The Supreme Court again. We're back here. We are back here, family. And we're gonna show some things tonight. We're gonna show some correlations because we submitted a letter to the Supreme Court. Ali, can you hear me, bro?
Yep, I hear you good. Can you hear me?
I hear you.
All right,
loud and clear. Beta Black N34 is in the building. Black Contraband. Peace to the fam. What's good? BTP Shanna is on deck. What's going on, sis? You know, I clear my throat a little bit, bro. I clear my throat a little bit. Man, we sent the letter to the Supreme Court once we were aware of this case. And it was after we've examined the oral arguments. And there was an article published. Man, I can't remember the name of that newspaper. And in that newspaper article, the headline read something to the effect of Supreme Court to determine if freedmen is a race-neutral term. Peace, Sister Isla, what's going on? Supreme Court to determine if freedmen is a race-neutral term. And Brother Ali would always point out that every time something crazy would happen in this movement, some attack against us by one of these cult leaders, etc., something like this would always pop up. We don't need anybody to attack anymore because it's just now on autopilot. So on autopilot. And the Supreme Court ruling today on affirmative action is bittersweet in some instances because it was designed, affirmative action, to make sure that our people got the same access, especially to education, that everybody else got. Because that would lead to, it was supposed to lead to better paying jobs. But we know that, what's going on, Sister Cindy? We know that that didn't play out that way, right? And that white women and quote unquote minorities that did not include the American freedmen benefited most. Sister Fate XX, what's going on, sis? The Freedman fam is in the building. Bond Dog, what's going on? He said, Lord Abba, peace. It was nice to see you debating the other day, fam. Definitely. I was telling the bros, I got a lot of messages saying I took it easy on dude. Well, not easy, but I went a little light on him. You know, I was trying to keep things to a low, a minimum. I was just letting him step in all of my traps. That's all. I have a method a methodology to how I debate. And I usually set traps during my debate, and I walk my opponents into them traps so that they could realize that the stuff that they're saying out of their own mouths does not comport with the facts that they clearly seen presented. So now they look like they are just lying and contradicting the facts just to be contradictory, just to be contrarian. BTP Riri is in the building. BTP Riri is in the building. Sister Isla, shout out to our sister Isla. Hold on. We got the newest member to the channel. Again, if you all want to support our channel, you can become a member of the channel. And Barn Dog said, I seen you debate a few times now. You were easier on him than I've seen in the past. No doubt. I'll take it. I'll take that. Sister Isla said it was a bloodbath. Peace, brother Errol Hairston Bay. Again, you can become a member of the channel to help support the channel. You can Cash App $ be the power. You can use that super chat feature, or you could donate directly to our 501c3, our website, usadof.org. That link is in the description. Shout out to our sister Roz, the DMV Freedmen are on deck. So, Ali, I don't know where I want to start. Okay, Barn Dog. We got Barn Dog, another member to the newest member to the channel. All right, that's what I'm talking about. We got contributions coming in from Sister Isla. Honors for the contribution to the channel. Oh, Ali, I don't know where I want to start right now. You know, we like to frame stuff before we start going. And I don't know if I want to read from our letter to the Supreme Court or if I want to get into the email responses we received from that letter. You know, we're going to blot out the names of these two high-profile DC attorneys that responded back to us. So what you want to do, bro? Or we just want to get into this thing?
Wow, where to start?
Go ahead, bro.
It's an interesting question. Where to start? Well, I guess we go ahead.
Let's frame it. Let's frame it. We're not going to read the whole letter. So what we'll do is we'll just pull up the letter, our letter to the Supreme Court. Make sure y'all hit that like button, family. Make sure y'all share this video out. You already know that the United Sons and Daughters of Freedmen, BTP, be the power. We're going to do this live stream tonight based on this the third day in a row. We usually don't do 3 streams in a row. We usually go once a week, but compelling freedman interest. Nice little twist in that.
Shout out to Isla.
That's right. Shout out to Isla.
Thank you.
Okay, so our letter to the Supreme Court. Man. This is how the letter starts. Freedmen as an American legal status, right? And there's a reason why we're bringing this letter up. Because when we submitted this letter, Sister Tiffany from California, she's aligned with the groups out in California that do reparations work. She reached out to some people in Washington, D.C. at the Supreme Court level. So shout out to that sister.
Shout out to Sister Tiffany.
You know, for including us in that reach out. You know, we still keep it official over here because we're just official over here, you know. But shout out to Sister Tiffany for that because we got some powerful responses. And I'm not gonna go through them. I mean, this letter, which we've read on the air before. Let me put that link in the live chat so that you all can click on it and pull it up. Shout out to our sister Satra Del Ree in the building.
I have something I would like to say.
All right, go ahead, bro.
Just to start it off, right? Just to give it the foundation. Obviously, they ruled against affirmative action in the Supreme Court. And the use of race-based legislation, etc., particularly with regard to college admissions. One of the things that they did was they mentioned the use of the terminology freedmen. And this is not the first time. This is something that they've been doing consistently for the past few cases that they've been dealing with. And it's just been very timely. It's been very timely, and it's very pertinent to what it is that we're doing in our advocacy and how we approach reparations, and even how we approached the Office of Management and Budget in the way that we did. See, this particular case, as we're going to see tonight, actually addresses that very issue, the issue of race as it pertains to its presentation coming out of the Office of Management and Budget, which is something that we did. And part of what they're saying, they address it from the same perspective that I did, which I use as a source. When I address the Office of Management and Budget, I use the American Anthropological Associations as my source in terms of showing the flaw in race. But in any case, I just wanted to say that, and I also wanted to say that our use of the terminology freedmen, for those who may not know, is rooted in the Reconstruction period, the same way that the court is demonstrating, and the significance of that rooting as it relates to reparations in terms of everybody keeps talking about delineation. The delineation was already made for us. This is the point. The delineation was already made for us back in 1863, which is the reason we keep pointing to the American Freedmen's Inquiry Commission, whose reports and recommendations led to the 1865 establishing of the Freedmen's Bureau and Bank. Now, people talk about, and I'm going to let, after this, then you can go ahead and jump into it, but people talk about the fact that the American Freedmen's Inquiry Commission didn't want us to have everything that we were supposed to have, and that's true. They only wanted the Freedmen's Bureau to be a temporary bureau, and their claim was that they didn't want us to become dependent on the government, right? So even within emancipation, as we've seen, even with General Order Number 3, as they was issuing them in Galveston, Texas, to the Texas freedmen, we had to consistently deal with white paternalism. So we understand that. Nevertheless, the larger point is that the use of this particular terminology already carved out the actual group that should be targeted for reparative justice. So the work, in other words, the work was already done ever since 1863. The work that a lot of people are trying to figure out how to do now with all of this lineage-based talk of reparations and all that, it was already done. The language was laid out already back in the middle of the Civil War. So I just want a bit of background as to where we're coming from with the use of this terminology, and then where it ends up today with the Supreme Court.
Man, powerful. And I want you all, as Ali was talking, I mean, we've been doing this so long, we know where things fall and fold in that. And sometimes it's just, I don't even want to say fortuitous. It's just, we've been doing it. So everything just aligns, right? And from the letter, it says, understand, from our letter to the Supreme Court, understanding the term freedman as an intended status as opposed to being a racially relative identifier is significant, as certain African Americans realign with the usage of American freedmen for delineation and disaggregation purposes. Did y'all hear that breakdown? See, we stress here at Be the Power that language, the United Sons and Daughters of Freedmen, Be the Power, that language is everything. I want to read that again, Ali, because I want people to understand what we just did here. Understanding the term freedman as an intended status, as opposed to being a racially relative identifier, y'all stick a pin in that, is significant, as certain African Americans realign with the usage of American freedmen for delineation and disaggregation purposes. Certain African Americans. Why did we say certain? Well, because African American is a broad term. And Neil Gorsuch, one of the Supreme Court justices, touches on that. And we're going to pull that up. Like, we're going to, Josh has this saying, he jokefully says, BTP is always right. And we kid when we say that, right? And, it's just designed to joke and make us laugh. And the fact that Josh said it and not me, right? Y'all should know that we kid when we say that. We kid, right? But man, we've been on point, family. So what I want to do is I want to stop sharing this. I want to stop sharing our letter to the Supreme Court. And I want to bring you all to the responses we received from the email to our letter. Let me see. Can I blow this up? Let me blow this up some more. All right. So let's get into this. I hope I think I bleep. Yep. I blotted out everybody's names.
And one of the names that's, well, both of them are involved in the case, but one of the names that's blotted out is actually directly referenced by the justices. But go ahead.
That's right. So this is the screenshot from the email. Y'all see the date there, November 30th, 2022. So that's the letter. That's the screenshot is of the letter that's in the email that we submitted to the Supreme Court through our sister Tiffany out in Los Angeles. And this is a response from one of the men that was on this case. He said, "Thanks, Tiffany. This is interesting." So of course I noticed that first off rip. This is interesting. That means he read it. But then he says, "But I'm afraid the court's procedures do not permit parties to submit anything further, except in the rare event of some intervening legal development, like a new court decision or a newly enacted law that would bear directly on the questions presented." So we weren't able to file our amicus curiae, I think I'm saying that right, brief. At least I got the first part right. I got the first part right. Amica is what the pronunciation said the first time. Okay, and I said, greetings to the person I'm responding to. This is Naheem Way, president of the United Sons and Daughters of, let me go there. President of the United Sons and Daughters of Freedmen. Is it possible that we can contact specific justices directly by email, like Ketanji Brown Jackson and Sonia Sotomayor? Now, the reason why I asked that question is because at the time, Ketanji Brown Jackson was arguing that these acts were race conscious. They got destroyed. When I tell y'all the arguments put forth by, I only seen Justice Thomas's, Justice Gorsuch. I didn't see anything from Kavanaugh because his oral arguments were enough for me when he said Freedman was a status, which is correct. But and Justice Roberts, I mean, they destroyed. The left-wing liberals got destroyed in this thing has so many layers, and I'm going to try to stick to the topic because there's so many things to touch on with how these people are always trying to do POC and BIPOC politics. No. Anyway, he responds, sorry, but I cannot give you legal advice in a matter in which I am already representing a party. So this person has some skin in the game. But then we got this one. By the way, this is from a completely different individual who's cited in that Supreme Court ruling, holding, as you know, is the more proper term. By the way, there is nothing stopping an individual from sending anything they want to a justice so long as they are not a party to the case. That doesn't mean anyone will read it or pay attention to it, but you never know. Now, the reason why I wanted to share that is because there were too many correlations between what we put in that letter and the decision of these Supreme Court justices. Too many that weren't there in any of the oral arguments other than freedmen being a political or a constitutional status. We got to talking among ourselves. Like, you know, are they listening to us? Brother Prime, shout out to our brother Prime. He was in a Twitter space. He said, does what's
Clarence
his name?
Thomas.
Clarence Thomas have a burner account? Is he listening in on these spaces? What's going on? So, Ali, let's get into it. Sister Antonia, what's going on? Our Boston Freedman is on deck. Easy Axe, what's going on? Said BTP is factually right. Shout out to the rest of the fam that's listening in. All right, so Ali, let's get into this thing, bro. Let me cue it up. Oh man, I want to read. I really want to read this thing. I don't want to be on here. It's so much. It's just so much, man, that we're not going to be able to get through all of this tonight.
Right, and we might, we probably gonna have to touch on this thing in a number of sessions because it really is a lot to really, comprehend and digest,
That's right. So let's stop sharing this. We at least know that somebody possibly, we hypothesize that somebody read our.
Well, I mean, from the interesting comment, it suggests that that particular person read it.
That's right.
So
that's right.
In any case,
let's hold on. All right, man. Ibrahim wanted to jump on. Ibrahim won't be able to jump on tonight. All right, cool. It's cool. This is a top. We could do a 3-4 days straight on this. So let us get into this, family. This is Justice Clarence Thomas concurring opinion, and he concurred with the majority. Students for Fair Admissions, Inc. versus President and Fellows of Harvard College on writ of certiorari. It's crazy because we used to know all of this stuff when we was in the Moorish movement. To the United States Courts of Appeals for the First Circuit, and Students for Fair Admissions, Inc. petitioner versus University of North Carolina et al. On writ of certiorari before judgment to the United States Court of Appeals for the Fourth Circuit, June 29, 2023. So I'm going to read. Y'all bear with us. We're going to get through this thing. And because we got some breaking down to do. Because it validates what we've been saying all along. And everybody fought us tooth and nail with lies that they knew were lies. There were people that knew that they were lying. They knew that we had the superior position, and they didn't want to yield for various numbers of reasons, depending on the individual or groups of individuals. But anyway, let's get into this thing. Oh, let me see. Can I blow this up? How does it look in the screen, bro? Does it look like I need
It
to
looks
blow it?
fine to me. I mean,
Okay.
from what I can see, and I'm on my phone, so it
All
looks all
right.
right.
I'm gonna blow it up a little bit more.
That's even better.
In the wake of the Civil War, the country focused its attention on restoring the Union and establishing the legal status of the newly freed slaves. The Constitution was amended to abolish slavery and proclaim that all persons born in the United States are citizens entitled to the privileges or immunities of citizenship and the equal protection of the laws. Amendments 13, 14. Because of that second founding, I got to pause right there, Ali. You notice I have that highlighted in the purple because there's only one person that calls these amendments, these Reconstruction amendments by this terminology, second founding. And that is the
Hmm.
foremost scholar on this period, which is Eric Foner. We at Be the Power have been beating that drum for, I mean, y'all, if y'all are following us on this channel, and especially in the Twitter spaces, you hear us reference Foner's book all the time. We tell you, get that book, Eric Foner's The Second Founding. Get that book. It will catch you up in various ways. There's some holes there. There's some holes there, but that's what we're here for. That's what we're here for. Quote, our Constitution is colorblind and neither knows nor tolerate classes among citizens. Plessy versus Ferguson, Harlan J. Dissenting. Now, I want to clarify this because Harlan is correct. And what we have as colorblind isms that come from the right wing is another version, Brother Ali, of construction of these amendments, the rulings, and the opinions that came out of them. This is what they did. They would
Hmm.
take a term like colorblind and flip it to mean what they want it to mean. And this is what modern justices. Now, remember when we had Sister Camilla on some months back, and man, I can never remember that term. She schooled us too. It's like saying it's a legal term for double-edged sword. I cannot remember
Hmm.
that term, and I can't see the chat right now. So, but it says because of that. So, well, I went through
You know what that
that.
means to me,
Mm-hmm.
right? My construction is when it says our Constitution is colorblind. What that says is when you read the um, proceedings of the Continental Congress as they were debating uh, adopting the Constitution as they were coming up out of the Articles of Confederation. One of the things that came up in the debates was whether or not to include the term white in the preamble to the Constitution. There were certain people who wanted the preamble to have the word white in it, to make it so that this country or that this document represents that this country is a country for the so-called white race. So you know how the preamble says "We the people do ordain and establish." They wanted it to say "We the white people," right? That was an argument. That was an argument. So if you don't read the debates or the proceedings of these congresses surrounding the adoption and ratification of these laws, etc., it's hard to contextualize what certain things mean. So when he says the Constitution is colorblind, what he's saying is that inside of the Constitution itself, after those debates in the Continental Congress, after those debates happen, what they're saying is, excuse me, not the Continental Congress. Anyway, what they're saying is that white was not put into the Constitution after they debated it. Because you got to understand, in the Articles of Confederation, the word white actually does exist. Very similar to the way white exists in terms of its usage in the 1866 Civil Rights Act. So it's in the Articles of Confederation. But as they left that to reform the United States government, they debated on whether or not to put white inside of the preamble. Those who wanted white to be in there lost that debate. So inside of the Constitution, you won't find any racial terminology at all. None.
Talk to him, bro.
None. You won't see. The only term that is mentioned that is considered a racial term is the word Indian, where they say Indians not taxed. But that's the only. But those is
and they mention that
those,
bro, in this holding. They mention that in their opinion.
Oh, okay, all right. So
I've seen it. Yeah.
You see, so I didn't even see that. But those are the only people mentioned by race are Indians not taxed.
That's right.
White is not mentioned. Black is not mentioned. Red is not mentioned. Nothing like that's mentioned in the Constitution anywhere. So when he says our Constitution is colorblind, that's what he's talking about. Then he goes on and says, and neither knows nor tolerates classes among citizens. By classes, what they're talking about is not racial classes. He's talking about first class, second class, third class citizenship.
That's right.
But what they're doing is they'll misconstrue that and try to pretend that by his use of the word classes that he's talking about racial classifications. That's not what he was talking about.
That's right. But
I just wanted to say that. Go ahead.
No, perfect. Because a lot of people need to understand what you just said. And this is what we do here at Be the Power. Shout out to our brother Devon from Brooklyn. We see you, fam. All right, let me finish reading. The court's commitment to that equality principle has ebbed and flowed over time. I would say that's an understatement. It's flowing right now. You know what I'm saying? But anyway, after forsaking the principle for decades, offering a judicial imprimatur to segregation and ushering in the Jim Crow era, the court finally corrected course in Brown versus Board of Education. Family, this is an educational right here. You know they dug into the books. Another book that we cite is the original meaning of the 14th Amendment. That is also referenced in these holdings.
It is. Yeah.
In the concurring opinions. It says, announcing that primary schools must either desegregate with all deliberate speed or else close their doors. It then pulled back in Grutter versus Bollinger, permitting universities to discriminate based on race in their admissions process. Now, remember, Erwin Chemerinsky, when he gave his expert testimony at the California Reparations Task Force, shout out to our sister Camilla Moore, because we see that final report has been submitted, and that train is moving out in California. So shout out and congratulations to Sister Camilla Moore and everybody that's on that commission who voted for ancestral-based reparations, or what is being commonly called lineage-based reparations, so that process can go through and not in that sense not survive a challenge from the right, because they're coming. It says, in order to achieve alleged educational benefit, yet the Constitution continues to embody a simple truth: two discriminatory wrongs cannot make a right. I've read Supreme Court stuff over the years. This is a masterclass that is going to be studied for years, family. There's some things that it was so funny. Let me just say, because I wasn't having a debate. Ali and Josh was having a debate. I'm usually the one that's debating with everybody in the clique. Me and Ali, me versus Ali, me versus Josh, me versus Logic, me versus Graham, right? And certain people don't never have debates against each other. I've been peeped that. But earlier, Josh and Ali was having a good spirited debate about this, and I was just cracking up, because I was still trying to take my notes at the same time, but I'm listening to the debate, and I said to myself, these two dudes don't ever debate. So it showed you the perspectives. Like, man, this is crazy. We're going to have to do another part to this. Okay. He said, he wrote separately in Grutter explaining that the use of race in higher education admissions decisions, regardless of whether intended to help or to hurt, violates the 14th Amendment. In the decades since, I have repeatedly stated that Grutter was wrongly decided and should be overruled. See, this same logic was applied in the Roe v. Wade case. Same logic. The Constitution. Let me finish. Today, and despite lengthy interregnums, the Constitution prevails, and that's a fact. As bittersweet as it is, it's a fact. It's a fact. Because the court today applies genuine strict scrutiny to the race-conscious admissions policies employed at Harvard and the University of North Carolina, and finds that they failed that searching review, I join the majority opinion in full. I write separately to offer an originalist defense of the colorblind Constitution. That's the key word there. So, yo, let me tell y'all, family, Justice Thomas, and I watched a good part of his documentary. That I seen it on YouTube. I think it may have been a PBS documentary. People call him a coon and a sellout. I've called him such over the years as well. There were certain things he has said over the years that I agree with. And I can probably search my Twitter wall and find those posts. He put, you know how they say, like, if you're a fan of the Marvel movies, they drop Easter eggs in the movies. Yep. Justice Thomas dropped Easter eggs in this piece based on his own lived experience outside of what we may collectively feel about him as being a sellout or a coon, et cetera, et cetera. And I need you all to read this when you get a chance. His opinion specifically. I write separately to offer an originalist defense of the colorblind Constitution, to explain further the flaws of the court's Grutter jurisprudence, to clarify that all forms of discrimination based on race, including so-called affirmative action, are prohibited under the Constitution, and to emphasize the pernicious effects of all such discrimination. Now, Ali, it's so much to read. I want to get to the highlighted parts. I don't know if I should just keep reading and then, because I don't want this to be a 3-hour stream, of course. And we already about to hit an hour. So, all right, look, I'm gonna read, and we'll just go in. You jump in when you need. In the 1860s, Congress proposed and the states ratified the 13th and 14th Amendments. And with the authority conferred by these amendments, Congress passed 2 landmark civil rights acts. Throughout the debates on each of these measures, their proponents repeatedly affirmed their view of equal citizenship and the racial equality that flows from it. In fact, they held this principle so deeply that their crowning accomplishment, the 14th Amendment, I believe the 13th Amendment is their crowning accomplishment. And that's based on Eric Foner's work. But
there are reasons why I think both are extremely important, but go ahead and finish.
All right. Oh man, let me get back to the page. All right.
The top of the yellow. In fact, they held this principle. Go ahead.
In fact, they held this principle so deeply that their crowning accomplishment, the 14th Amendment, ensures racial equality with no textual reference to race whatsoever. This is factually true.
Yep.
This is factually true. The history of these measures, these measures' enactment renders their motivating principle as clear as the text. All citizens of the United States, regardless of skin color, are equal before the law. Now, some may say, yeah, but that hasn't applied and yada, yada, yada. He addresses that. I do not contend that all of the individuals who put forth and ratified the 14th Amendment universally believed this to be true. Some members of the proposing Congress, for example, opposed the amendment. And the
That's true.
historical record, that's right, particularly with respect to the debates on ratification in the Senate, in the states, is sparse. Nonetheless, substantial evidence suggests that the 14th Amendment was passed to, quote, establish the broad constitutional principle of full and complete equality of all persons under the law, end quote, forbidding, quote, all legal distinctions based on race or color. And he's given the citations, Brown versus Board of Education. That was Justice Harlan's view in his lone dissent in Plessy, where he observed that, quote, our Constitution is colorblind. It was the view of the court in Brown, which rejected, quote, any authority to use race as a factor in affording educational opportunities. And it is the view adopted in the court's opinions today, requiring, quote, the absolute equality of all citizens under the law. So I want to read this stuff, but I want to get.
Yeah, let's just skip to the highlight sections because there's a lot in between, and we're gonna have to do this in multiple parts.
That's right. It says its framers viewed the text broadly, arguing that it allowed Congress to legislate not merely against slavery itself, but against all the badges and relics of a slave system, or what is commonly referred to as the badges and incidents as a result or as a consequence of slavery. When you understand what Justice Thomas did here, family, when you understand what he did here and how moving forward, all of this is going to be useful in our push for reparative justice and our want.
And this here, he's talking about
for American freedmen, then you'll understand. Go ahead, bro.
And this one, just be clear, he's talking about the 13th Amendment.
That's right.
In this particular section. So I just want people to understand what this highlighted section is about the 13th, not the 14th Amendment.
That's right. That's right, Sister Isla. He's lining up the play. She said, yeah, I thought that too. He's lining up the play for what is to come. I mean, it's so much we got to touch on. It's so much, but we're gonna get to it. So let's try to scroll some more. All right.
Yeah, let's just deal with your highlighted sections, and then let's deal mainly with the highlighted sections, just for the sake of time, because we'll run out of time.
I do want to read this part. The amendments also authorize, quote, Congress to enforce its terms by appropriate legislation. Now, you always hear us say on Be the Power, whether it's on this channel or in our Twitter spaces, that Congress has never defined the badges and the incidents of slavery. I'm going to stop right there, and I'm going to continue to read, but I want y'all to keep that in the back of y'all's minds. Authority not granted in any prior amendment. Now, this is coming directly from Eric Foner's book, because this is what Eric Foner highlights in his book. He places emphasis on that authority not granted in any prior amendment. And that is the section 2, which he has right here, of the 13th Amendment. Powerful, powerful section in this Constitution of this or these United States of America. Proponents believed this enforcement clause permitted legislative measures designed to accomplish the amendment's broader goal of equality for the freedmen. Equality for the freedmen, not the black folks, because that's racial. And here,
that's right,
they are speaking to the status of the people, and he's going to say that. So, oh man, this part right here too is so powerful. But we're going to scroll past all of this because he's talking about the black codes. He's laying out the history
And
and
you
how
see, he
Congress.
mentions Spona, the
That's
second
right.
founding. He's
That's right.
citing them.
That's right. That's right. That's right. Ah, Ali is so hard, including limiting their freedom of movement and barring them from following certain occupations, owning firearms, serving on juries, testifying in cases involving whites, on voting. Eric Foner, the second founding, a book you hear us harp on. Harp on.
A little note for people listening, right? Because we keep dropping these, and then I'm gonna shut up. It's very important that our reparations claims are rooted in the freedmen and the Reconstruction period. It's very, very important that this is done. The 13th Amendment and its Section 2, and in my opinion, is where the power for Congress to do what needs to be done in terms of reparations will come from. I just wanted to drop that, and we
That's
can keep going.
Go ahead,
that's it.
John.
That's right. No, you're right. You're right there. I mean, I just, hey man, the Congress is empowered by Section 2 to eradicate all badges and incidents of slavery, badges, incidents, relics, etc. of slavery, and we contend that one of the said badges is the resulting wealth gap between the freedmen wealth and everybody else, and especially, you know, if you especially other groups that have been in America for as long as the freedmen, or we can make any other type of assertion on that end, but eradicating the badges and incidents of slavery, that is what the 13th Amendment, Section 2, empowers the Congress to do. And I would say that it's not only an a power that they have at their disposal, but it is also a responsibility for them to exercise this power.
Yes,
Go ahead.
indeed.
All right. Ooh, this man, there's so much powerful information here. I feel bad that we can't just get through all of it, man. We'll be here to 2 a.m. trying to. The
Well, we got part 2
1866.
coming.
That's right. The 1866 Act's evolution further highlights its rule of equality. To start, Dred Scott v. Sanford had previously held that blacks, quote, were not regarded as a portion of the people or citizens of the government, end quote, had no rights which the white man was bound to respect. The act, however, would effectively overrule Dred Scott and ensure the equality that had been promised to blacks. I got a point, because we did this research years ago, family, when we was in the Moorish movement and we were debating people. I mean, we was crushing people. The Dred Scott case, they got it all wrong, even a lot of the Moors. And we found, and I think Ali did like a search on my Facebook page about some months back, man, and he was pulling up all of this stuff that we was talking about, this 1866 civil rights back in 2013, 2014, 2015, breaking this very thing down, family. We were always on this path. That's why we say we came into this space as leaders. We didn't come to sit up under anybody at all, which means we never splintered off from anybody. We came to contribute what we had to a discussion that was taking place that we were passionate about, which is reparations, period. So let me see. I'm going to read this part. But the act went further still. On January 29, 1866, Senator Lyman Trumbull, the bill's principal sponsor in the Senate, proposed text stating that, quote, all persons of African descent born in the United States are hereby declared to be citizens, end quote. And you know they did their research because they went into the Congressional Globe on this joint, something that we've been citing from since the same time period, Brother Ali, that Congressional Globe.
That's a fact.
The following day, Trumbull revised his proposal, removing the reference to African descent and declaring more broadly that, quote, all persons born in the United States and not subject to any foreign power are, quote unquote, citizens of the United States.
And let me say this.
Go ahead, bro.
Let me say this. This is an example, right? Leave it right there for a second about, because I want people to see the 14th Amendment's true, Section 1 of the 14th Amendment, and what it means when they say, and subject to the jurisdiction thereof, right? They say all persons born or naturalized in the United States, born and naturalized in the United States and subject to the jurisdiction thereof. That has been debated, and subject to the jurisdiction thereof. What does that mean? Well, the 14th Amendment, Section 1, is actually borrowing the language from the 1866 Civil Rights Act, where it says, where it says all persons born in the United States and not subject to any foreign power. So when they say in the 14th Amendment and subject to the jurisdiction thereof, what they mean is and not subject to any foreign power. So when people don't actually naturalize and cast off their allegiance to a foreign power and they're in this country, they're still citizens or subjects of that particular foreign power, and not necessarily politically subject to the United States jurisdiction, which means if particularly when they have extradition treaties or whatever, the United States can deport people, those other countries can bring those people back to their country. So all of these illegal aliens who are coming here and having babies, for instance, I'm just going to speak real quickly to how the Democrats in particular have misconstrued the meaning of the 14th Amendment to make room for all of this immigrant invasion that's occurring and claiming birthright citizenship. This is the birthright citizenship that Donald Trump wants to get rid of because of the misconstruing of the 14th Amendment, and where it says and not subject to a foreign power. They're construing that so that these people can come in and have babies in the United States, even though the parents are still subject to foreign powers. They're construing it so that when they come and have babies, the babies are going to be deemed as citizens because they was born here. But that's not the intention. That's not the true purpose of the 14th Amendment. And so I just wanted to point that out, because what these people are actually doing in this Supreme Court case is showing how these amendments, these particular amendments that were put in place for the freedmen families, have been misconstrued and expanded through false constructions to include all kinds of people in all kinds of circumstances that it really wasn't intended for. These things were put in place for our families. And that's the real point that these folks are actually making, whether people realize it or not. Because I saw someone made a Twitter post going in on Justice Clarence Thomas and calling him all kinds of names and everything. And I understand them being mad about the taking away of affirmative action. I get the emotionalism behind it, but the truth of the matter is what they're talking about from my perspective is that these things have been expanded to include so many things that it never was intended to include. And now it's time to actually narrow this stuff. Particularly if they're going to have these things in place where our families are the ones who benefit from it the least, when they were put in place for us specifically, and everybody else is benefiting, white women, gays, POCs, you name it. Everybody else is benefiting from this stuff. Foreigners, people who are subject to foreign powers, but they're coming here and benefiting off of our Reconstruction amendments, our civil rights laws. It's a problem. It's a problem. So for me, I don't see the issue with the way that they're trying to narrow it in terms of its true construction. Go ahead.
I'll scroll down. Excellent breakdown, bro.
Hey, bookmark this right here. That need to be a clip, brother.
That's right. I highlighted this from Trumbull. It says he said any statute which is not equal to all and which deprives any citizen of civil rights which are secured to other citizens was an unjust encroachment upon his liberty and a badge of servitude prohibited by the Constitution. We talk about what is one of the, Josh, what do we always say is one of the main badges of slavery?
Oh, what is it called? The exception clause of the 13th Amendment?
No. The badges, like what's a today badge of slavery? The wealth gap. Remember, we
Oh,
always say that. I
definitely.
think you start saying that, matter of fact.
Yeah, that was the original one I said. We expanded it
Right.
to talk about other ones like
That's right.
um and today how they can use that exception clause to kind of still put people into slavery in the prison system. And then
Just about to go there. Thank you for saying that. Go ahead. I ain't got
yeah,
it. Go ahead.
nah. I mean I mean a badge of slavery. I mean they tell you that you still can do slavery if you put them in prison. And then once they get out, they can literally be citizens with disabilities with Jim Crow laws, Jim Crow disabilities on them. So,
That's
but
right.
go ahead, brother. Naeem.
That's right. Oh, we got Ibrahim in here. I'm gonna say we almost got a full team. There's some voices, there's two other voices I would love to hear from our team on this tonight. But it is what it is. All things in this time. Providence is moving. Providence is moving. Let me see. I wanna get to the race neutral part, right? So let me make sure okay. And because we're gonna be stuck right there, family. We're gonna be stuck right there. But this right here, this part right here is important. And this is what was being shared all over Twitter today. And people started to realize, you know what, man? Them brothers from BTP, the United Sons and Daughters of Freedmen, that's pushing this Freedmen thing forward, they're right. And they've been saying this for the longest. Let's read. Matter of fact, you know what I'm
You
gonna
want to
do?
start a little bit before that? Yeah.
Yeah. Let's start because they cooked. They cooked Sotomayor, Katana. I think I think Justice Thomas cooked Sotomayor the worst. Sheesh, they cooked them. So I'm gonna start from the top of part E, in this opinion. Despite the extensive evidence favoring the colorblind view as detailed above, it appears increasingly in vogue to embrace an anti-subordination view of the 14th Amendment, that the amendment forbids only laws that hurt but not help blacks. Such a theory lacks any basis in the original meaning of the 14th Amendment. Respondents cite a smattering of federal and state statutes passed during the years surrounding the ratification of the 14th Amendment. And Justice Sotomayor's dissent argues that several of these statutes evidence the ratifiers' understanding that the Equal Protection Clause, quote, permits consideration of race to achieve its goal, end quote. Upon examination, however, it is clear that these statutes are fully consistent with the colorblind view.
Come on.
Go ahead. You want to touch on that?
No, let's keep going.
Okay, let's keep going. Start with the 1865 Freedmen's Bureau Act. That act established the Freedmen's Bureau to issue, quote, provisions, clothing, and fuel needful for the immediate and temporary shelter and supply of destitute and suffering refugees and freedmen and their wives and children. And the setting apart for those of loyal refugees and freedmen. Abandoned, confiscated, or purchased lands and assigning to every male citizen, whether refugee or freedman, not more than 40 acres of such land. The 1866 Freedmen's Bureau Act.
Now, let's be clear there. Let's be clear there. This is a law. This is not a special field order. This is an actual act of legislation talking about the allotments of 40-acre plots, even though they were supposed to purchase. When you read that section that they're coming from of the 1865 Civil Rights, 1865 Freedmen's Bureau Act, what you're going to see is that these people were supposed to purchase that land for, I think, like 6% of the actual value of that particular land. This is in all of the insurrectionary states. So when we say to you that the American freedmen are the heirs to a vast estate, we're not just talking about the Sea Islands in the areas outlined in that special field order, which was not a law, but we're talking about the actual legislation and what it says as this man just cited it for this particular case here today. So remember, heirs to a vast estate. In other
Heirs.
words, we've been cut off from access to inheritance
That's
that
right.
this government legislated we were supposed to have.
That's right. That's right. Let me continue. The 1866 Freedmen's Bureau Act then expanded upon the prior year's law, authorizing the Bureau to care for all loyal refugees and freedmen. Importantly, however, the acts applied to freedmen and refugees, a formerly race-neutral category, not blacks writ large. And because, quote, not all blacks in the United States were former slaves, end quote, freedmen was a decidedly under-inclusive proxy for a race. You all pull up the definition of under-inclusive, and what he's basically saying is what we've been saying all along on this platform, is that our status was incidental to our race.
And what he's saying is narrowly tailored.
That's right. Very narrowly tailored. That's right.
And brother Naheem, I don't know if you got. I know I don't want to make us skip around, but I don't know if you got into the opinion of I think it was Justice Roberts, when he broke down what is permissible in terms of discrimination, and like when you're dealing with permissible discrimination, you have to meet the two parts of the strict scrutiny test. And number one is it has the there needs to be a compelling governmental interest that satisfies. And then number two, that is what's the number two? That is narrowly tailored, right? I think that's number two. And what you see is that it's not just broad and all that. So what you see is when we are making our claim for reparations, we're saying that the compelling interest is to eradicate the badges and incidents of slavery, and we can identify those. And then it's narrowly tailored because we're not talking about all black people. We're not even talking about a racial category. We're talking about we narrowly tailor this thing down to the American freedmen families today, not even all American quote unquote blacks. We're talking about American freedmen families, those people who can trace their direct line ancestors back to the harm that was committed that caused it, that perpetuate a straight line of continuous badges and incidents of slavery. And he gets into language that pretty much makes the case, that says what we're saying, and it allows us to say, okay, well, based on what you're saying, Justice Thomas, we got a clear case for reparations. It shouldn't be any problems based on what you're saying. But go ahead, brother Naheem. Go ahead,
Definitely.
Continue.
Excellent breakdown. I want to read this part. It says, and advocates of the law explicitly disclaimed any view rooted in modern conceptions of anti-subordination. To the contrary, they explicitly clarified that the equality sought by the law was not one in which all men shall be 6 feet high. Rather, it strove to ensure that freedmen enjoy equal rights before the law, such that each man shall have the right to pursue his own way of life, liberty, and happiness. we were denied these things. We
That's right.
were. And when we fought under the racial classifications of Negroes and black people and colored folk. We didn't fight using the status as our shield. We didn't fight using the freedman status as our cloak. We fought using their terminology that they created. And we have people that are out there right now trying to fight against us over something that they don't even understand. They don't even understand this at all. So I want to.
That's a fact.
Let me see. I want to get to. Okay. Let's read. Let's read. It says, thus, while this legislation.
Who is this coming from? Who is this coming
still
from?
Justice. This is still Justice Thomas.
Okay.
So each page is going to show who's giving the opinion. And after Thomas, we're going to get to Gorsuch, because Gorsuch says some things that, again, we've been saying for years. And you've heard us say here on Be the Power, information that we introduced into the reparationist collective nationwide. Thus,
yes, indeed. Well, look. Can I say one thing before we jump into that?
Mm-hmm.
And that is, for people listening, you have to understand that we're bringing all this up not because we, agree with everything or the total ideology or the political leanings of any of these people. It's because we understand the game and how it's played, and we already know the moves that are being made. We know what they're going to say. And so we're saying is, if you know the game they're going to play, if you know the rules of the game, why are you still trying to buck the rules? Like, once you pick the ball up, you can take 2 steps and go lay the ball up, or why are you trying to pick the ball up and think you can run all the way down the court, from half court and run all the way, take 100 steps and still trying to shoot and then put the ball back down, dribble? Like, that's not the rules of the game. I know it may feel like it because you're used to playing football, but that's not the rules of basketball. So if you know that's how the game is played, then you just understand, play the game accordingly. But for some reason, people still are trying to play by different rules of the game, and we're trying to highlight is, like, we got to wisen up, we got to smarten up, and we're highlighting that here. Go ahead, brother.
That's right.
You know what? We've been doing this wrong for about 60, 70 plus years.
That's right.
And unbeknownst to our surprise, Naheem, you always talk about providence. And unbeknownst to our surprise, I believe just maybe a conservative Supreme Court may have been a gift for us to American freedmen. And I say that because, how we feel about immigration, they seem to have some slight parallels, to how they feel about immigration versus the old America. And what they're saying is that, we've seen this in several Supreme Court justices' opinions and in a few rulings from the Supreme Court and what the OMB is trying to do. And they trying to get away from race, and they trying to get away from like all of this POC language and minority language, and just deal with it straightforward as it aligns with the Constitution. And that benefits us, right? It's kind of like we've been doing it so wrong and so backwards for so long, they basically lean us to the well, but they can't make us drink. And that's where the United Sons and Daughters of Freedmen come in. They say, hey, we've been saying this all along anyway. The truth don't need no defense. We've been saying it's all about status. Well, here you got the highest court of the land, and they're basically forcing us to see. And what I mean by us, I mean like broad stream, Black America, white America, American citizens. They forcing us to see it's not about that. It's about status. When you go back and look at the opinions that came down from when the whites tried to adopt the Native Americans' children to this affirmative action hearing, even in some past hearings, it keeps coming back to the same thing. So I feel like, this isn't what we wanted, but it may be what we need when you look at the opinions of Thomas and Kavanaugh and Ketanji Brown Jackson, even though she's a Democrat, but still, maybe a conservative Supreme Court is what we needed to actually get us over the hump and stop running around with these POC blinders on.
Indeed, indeed. So I want to read this part because this is and we might go to Gorsuch after this, and then we could jump around a little bit because this part is important. It says, thus, while this legislation appears to have provided discrete race-based benefit, its aim to prohibit race-based exploitation may not have been possible at the time without using a racial screen. Now, he's talking about how servicemen were being exploited for their labor, right? So this was a law. And he says this legislation appears to have provided a discrete race-based benefit. Its aim to prohibit race-based exploitation may not have been possible at the time without using a racial screen. In other words, the statute's racial classifications may well have survived strict scrutiny. And that's something for us to look into. I like that he found that there is something in the historical record that was based on race. And it's quite possible that that statute could have passed strict scrutiny. Quite possible, right? He speaks of this other law. He says another law, almost in contradistinction, another law passed in 1867 provided funds for, quote, freedmen or destitute colored people. Freedmen or destitute colored people. That sounds like, or signifies that there may be some other people that are not freedmen. Right?
Right.
It's
no,
like,
yeah, right.
Mhm.
Colored people, meaning people who they classified as colored that may have been free people of color at the time of emancipation, etc. So anyway, that's it.
All right. Hold on. All right. Let me get back. All right. In the District of Columbia. So this was in Washington, D.C. However, when a prior version of this law targeting only blacks was criticized for being racially discriminatory, quote, it was defended on the grounds that there were various places in the city where former slaves lived in densely populated shanty towns. Congress thus may have enacted the measures not because of race, but rather to address a special problem in shanty towns in the district where blacks live. And Ali was breaking down earlier, like shanty towns with like these little really messed up areas where people basically, it's like homeless encampments almost. Have you ever seen a homeless encampment, right? A bad one, a bad homeless encampment. You could look at, you could get an understanding of what a shanty town is. But there's a legal term for what the Congress did here. And it's called a compelling, legal term, a compelling governmental interest. This was a compelling governmental interest that because there was a special problem in these shanty towns, in the district where blacks live, the Congress felt compelled to remedy that thing.
And understand something. This is a law that was passed in 1867, right? During that time period, there was an influx of freedmen specifically into that area who have been fleeing the South, etc., and coming to DC in particular. So much so that in 1871 they revoked the charters of Georgetown and Washington, the city of Washington, to create the District of Columbia in order to accommodate the large influx of the freedmen who were coming from the South and other areas into the District of Columbia. So That's what happened, because they were saying that those municipal governments that were established as the city of city of Washington and the city of Georgetown um, could not handle that large influx of the capacity of people that were then coming into that city. So in 1871, what you'll see is the District of Columbia Organic Act, right, where they then turn that particular city into a federal district and created the municipal government that is now controlled by Congress. And that was done in order to be able to accommodate this large influx of freedmen coming into this area after the Civil War was over. So that's the thing that's very important, is that all of this stuff is so deep that all of these laws that's being done at this time are very, very freedmen specific. Even the 1871 Organic Act of the District of Columbia Organic Act of 1871.
That's right. That's right. And I want to highlighted this, of course, because look at what Justice Thomas says. The government can plainly remedy a race-based injury that it has inflicted. Those such remedies must be meant to further a colorblind government, not perpetuate racial consciousness. So Brother Black Contraband said that he took a shot at reparations, and I'm going to keyword that he put today's 17-year-olds after all did not. So that's the keyword. But understand, if that's a shot at reparations, in my opinion, this is a booster shot to reparations. I want to read it again. The government can plainly remedy a race-based injury that it has inflicted. Who is the culpable party in our fight for reparations? The United States government, through its subsidiary states as well as itself.
That's right.
Helped to drive the wealth gap that we have now. The book,
okay.
The Color of Law. Hold on, Ali.
Mm-hmm. Go ahead.
Color of Law, right? Richard Rothstein. What? Man, can y'all see that? Just
Yeah.
visible. Okay, Richard Rothstein. What does he say? A Forgotten History. The subtitle is A Forgotten History of How Our Government Segregated America. How our government did that. Let me read this again before y'all go in. The government can plainly remedy a race-based injury that it has inflicted, though such remedies must be meant to further a colorblind government, not perpetuate racial consciousness. Hey, we agree.
I agree 100%. And this is why you'll see people that are listening to us, you'll hear me in many instances reference the Declaration of Independence. It's very important, because in that declaration, which is considered the cornerstone document for the founding of this particular nation as a body politic, in that document is enshrined these principles of liberty. It says very specifically that all men were endowed with these unalienable God-given rights for which governments were instituted to protect all men. And again, this debate about whether or not the Declaration of Independence should have been exclusive to white people, which many people think, a lot of our people think, oh, the Declaration of Independence was exclusive to white people. But see, what you don't understand is that was a debate also, that the Declaration of Independence should have been exclusive to white people. This was a debate between the northern colonies and the southern colonies. There was a few southern colonies who wanted it to say all white men were endowed with these unalienable rights. They debated that in the Continental Congress, right? And that was a suggestion that was shot down by the northern colonies. Because why? They had members of the colony who were citizens of the colony, people like Crispus Attucks or Prince Hall and others, who fought as patriots on the side of the Union to help establish the independence and sovereignty of this thing called the United States of America. So they knew that these men were already members of society, these quote unquote blacks or Negroes or colors, whatever you want to call them. They decided against that. So the Declaration of Independence is also colorblind. And don't think that they weren't aware of color. They were very much aware of color at the time that they adopted this declaration and started to fight for their independence and sovereignty. So the truth of the matter is, going all the way back to the Declaration, which was founded on the idea that all men were endowed with these unalienable God-given rights to life, liberty, the pursuit of happiness. Our people were cut off. Our access to this was abrogated. Not only that, re-enshrined in the Constitution with the Three-Fifths Compromise, as well as the Fugitive Slave Clause, and then Congress comes with the Fugitive Slave Acts. So the fact of the matter is, this government definitely did things to harm a whole segment of its citizenry, and now, by way of the 13th Amendment, has the authority to eradicate the problems that has caused for generations.
That's right. That's right. I want to harp on this part, but I thought this was interesting. Sorry, an error occurred. What's going on? What's going on? Don't start messing up on me. Don't start messing up on me. Can y'all still see the?
I still see it.
Oh, it cut off on me. Hold on. That's interesting. All right, All right, we'll get into this and then I'll pull it back up. Civil rights in the South, explaining that while both Asians and blacks have at the same time fought against similar forms of
Now it went out. It went out.
Yeah, I got some lag going on right now.
Oh yeah, so probably internet connection or something, maybe. Or it could be like if you're running a PDF, sometimes I have issues, when I'm running my PDF application, it's slow down for some reason or another. But this is very interesting.
This whole
Is this the piece where
process.
They get into the OMB? Is that what you're getting ready to go into?
Say it again, bro. Because I think I'm just having internet issues.
Yeah, I was asking if you getting ready to look at the piece where they talk about the racial classifications as laid out through the OMB.
Yep. I was highlighting that last part because it spoke about status, but we're gonna get into
Absolutely.
that point. Let's get into that part because that's from.
Oh, you could go. I mean, yeah, no doubt. Let's do that. Let's definitely do that because there's some things that I want to, look. Everybody knows that we presented to the Office of Management and Budget with regard to establishing a category that would be specific to our particular families in this country, those of us who are quote unquote up from slavery, as they say, in this country. And so we proposed an actual ethnic category. Some people have a problem with that. That the usage of the American freedmen terminology as an ethnic category, which what we were trying to do is make the distinction for people who didn't understand that us using this name American freedmen was very different thing than using than making clear that this freedman status as a standalone term was something different, right? And that even though the names freedmen versus American freedmen are both rooted in the emancipation of our people, that a name is just a name, right? So a name is a name, right? And so we were talking about using American freedmen as an ethnic nomenclature to help with the delineation process of our people as a particular group in this country with our own history, cultural continuity, plight, etc. At the same time, still acknowledging that us as a freedman class of people have our own status, just like they talked about with the Native Americans having not being a racial group, right? This is not a racial group, but this is a actual political class of people. So the fact of the matter is the same way we were trying to explain to folks that these people use names that work for double purposes is what we were trying to make clear, but for whatever the reason, it wasn't really being understood. So when you, for instance, when you see Chickasaw Freedmen, right? This is considered a ethnic name for these people. The Chickasaw Freedmen is an ethnic terminology for them, but it also denotes their status as a political class of people with relation to the larger Chickasaw tribe. So that was the point, right? And so for whatever the reason that wasn't translating, people didn't understand it. So we got a lot of pushback.
Or there was, you had some people that wasn't trying to understand it as well.
Right. Right. And so the court in that particular Indian case acknowledged it for basically the same thing that we were saying. It doesn't really matter. The point is understanding, right? It's not necessarily the words. It's the way the courts understand it and the way these things are accepted and utilized throughout the judiciary, throughout Congress or whatever, right? You have the ability to self-determine. You have the ability to actually define what these things mean as a self-determined group of people. Folks don't believe that. It is what it is. So so this guy in this case actually touches on these racial constructs, and I guess we can get into that if you want to.
Let's get into that. This is from Gorsuch in his concurring opinion, and I'm gonna start here. Start with how Harvard and UNC use race. Like many colleges and universities, these schools invite interested students to complete the common application. As part of that process, the trial records show applicants are prompted to tick one or more boxes to explain how you identify yourself. The available choices are American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, Hispanic or Latino, or white. Now, you all know that we go through these racial classifications on this platform for a long, long time. It says applicants can write in further details if they choose.
Like Negro. Like Negro.
Right. You can write in Negro if you
of the Black or African American race, but you prefer to use Spanish words or Portuguese words, you can use Negro. And if you're a white person and you want to use Spanish and Portuguese words, you can call yourself Blanco.
Or French, Noir, or you can Noir, Arabian words or Arabic words.
That's right. That's right.
You can say what's the what's the term for that?
The Arabic would be like Sudan or something, right?
Yeah, there you go. Yeah.
That's one of them. That's one of them. All right, it says, where do these boxes come from? He's talking about the boxes that you tick for these racial classifications. Bureaucrats. A federal interagency commission devised this scheme of classifications in the 1970s to facilitate data collection. See David Bernstein, The Modern American Law of Race. Anyway, that commission acted without any input from anthropologists, sociologists, ethnologists, or other experts. Brother Ali was the first one to share that with me, and this came from the Anthropological Association. What is it? The American Anthropological Association.
The American Anthropological Association's statement on race.
That was
years ago.
2011. Ali showed me that. 2011. Anyway. Excuse me. Let me see. Recognizing the limitations of their work, federal regulators cautioned that their classifications, quote, should not be interpreted as being scientific or anthropological in nature, nor, notice, they italicized this next sentence, which gives it its emphasis, nor should they be viewed as determinants of eligibility for participation in any federal program. Let's pause there, Ali. Let's pause there, because I want you
we heard that before.
Yes, right? Because our audience that follows us, like Brother Black Contraband said, let me see. Black Contraband said, BTP put me up on game with Directive Order 15 before the OMB started up. And this was one of the things that we always stressed, right? And we always stress the part where it says that these classifications are not based on anything scientific or anthropological in nature. And they should not be used. Let me read it verbatim.
Yes,
Nor
verbatim.
should they be viewed as determinants of eligibility for participation in any federal program. Now, Ali,
Yep.
we emailed someone about this particular topic. And
Yes, we do.
because we were concerned that a certain criteria that was established might get called into question based on this sentence right here in the email. Matter of fact, go ahead, you break it down, Ali. And then jump in, Josh.
Well, so here we are. Here we are, right? And you're absolutely correct. We did have a conversation about this, right? And it's very, very important that I think we get to the place where we can really just be honest and look at this thing from an honest perspective. That is a disclaimer that these people who are in charge of the administration of these racial classifications throughout federal agencies, the usage of it by the Census Bureau. Not only are these racial classifications used by federal agencies or the Census Bureau, but they're also used by state and local agencies, including law enforcement.
That's
so
right.
When you're dealing with racial profiling is going to go all the way back to the racial classifications as outlined by this agency that this man is talking about right now, which is the Office of Management and Budget, who he's calling a bunch of bureaucrats who put these things, who devised these racial classifications for the purpose of data collection and statistics without the input from any of the professionals who put in the rigorous work and are knowledgeable in the area of anthropology, ethnology, etc. Then they laid a disclaimer out. Well, we're letting you know, even though we're using this stuff, none of it is based in science or anthropology. It's not. It's not based in science or anthropology. So for all of the people who love this stuff and who are so emotionally connected to all of these things, I want you to understand that what you're doing is you're emotionally attaching yourselves to something that these people who constructed all of this stuff is telling you none of it is based in science or anthropology. None of it. And these things should not be used as determinants of eligibility for any federal program. That would include federal reparations, correct? So what I'm saying is, it's very important that we start looking at this thing with the right eyeball. We have to.
That's
if
right.
we're serious about it, we're going to have to do that. And we're going to have to figure some things out. And I think this court, what they're doing, and I'm so glad that it's happening, and to Ibrahim's point, maybe we did need a right-leaning court, a conservative court, to come in and actually make this stuff clear, because the Democrats are so caught up in the expanding, misconstruing and expanding the meanings of things that all of this stuff now gets lost in the sauce, right? It take a conservative court to bring it back to its origins. Let's bring it back to where this thing came from, the original intent. What were the issues that the Congress was trying to address when they were enacting these laws? What were the issues that the city of Georgetown or the city of Washington were trying to address when they enacted these laws, that where they're talking about destitute freedmen or colored people? What were they trying to do? They were trying to address specific conditions that were particular to these American freedmen and the so-called colored people or blacks who may have been free at the time of emancipation. emancipation, but also put in this bottom caste position in society. So that's what's happening. And I think that we got to be very clear that we can't consistently use this thing, especially in light of this particular case. It's telling us you can't do this, right? You can't use these racial classifications in this way. So as I said before, trying to invoke race, whether it is in the form of legislation, whether it's in the form of some criteria developed to determine who the eligible recipients of reparations should be, invoking race in any of those instances, from my perspective, is adding an extra degree of incline to an already uphill battle. Okay, so that's my take on it, and we can go into a little bit further.
That's so clear. Oh, my bad. My connection cut out. I thought you had paused. But that's such a clear, concise, like, example, man. Every time you say that, I think about, like, if you ever been to the gym and you put, like, you get on the treadmill and you put that incline on the treadmill. Now and you getting real tired. Now imagine if somebody took the whole treadmill and put that on the hill, and then put the incline up some more, like that. That's a totally different.
And throw on a pair of rollerblades while you're at
it. Yeah, yeah.
Throw on a pair of rollerblades. All right, let's get through this part, and then Josh, just jump in.
Yes, because we got to get to the black part, please.
Yes. So, okay, these classifications rest on incoherent stereotypes. Take the Asian category. It sweeps into one pile East Asians, Chinese, Korean, Japanese, and South Asians, Indian, Pakistani, and Bangladeshi. Something we've said here on Be the Power. Even though together they constitute about 60% of the world's population. Bernstein Amicus Brief, well, that's the source. This agglomeration of so many peoples paves over countless differences in language, culture, and historical experience. It does so, even though few would suggest that all such persons share similar backgrounds and similar ideas and experiences. That's why I personally still call Japanese, Chinese, and Koreans by the term Orientals, because it makes sense to me. Consider as well the development of a separate category for Native Hawaiian or other Pacific Islander. It seems federal officials disaggregated these groups from the Asian category only in the 1990s and only in response to political lobbying, something that we don't have. We're doing it on our own. You see the MENA
then we talk
right
about
now,
flexing political muscle.
Flexing that
That's how that happens.
Muscle. That's right.
Yep.
And even that category contains its curiosities. This is Gorsuch breaking down the racial categories that we've broken down right here on Be the Power and in many, many Twitter spaces. It appears, it continues, for example, that Filipino Americans remain classified as Asian rather than other Pacific Islander. And this makes sense. Somebody from the Philippines should not be classified as Asians because they are actually Pacific Islanders. I never even thought about that until I read this, fam. Never thought about it until I read this. The remaining classifications depend just as much on irrational stereotypes. What he called it. This helps us moving forward, family. Know that this helps us. The Hispanic category covers those whose ancestral language is Spanish, Basque, or Catalan. But it also covers individuals of Mayan, Mixtec, or Zapotec descent who do not speak any of those languages and whose ancestry does not trace to the Iberian Peninsula, but bears deep ties to the Americas. The white category sweeps in anyone from Europe, Asia, west of India, and North Africa. Y'all hear us bring up the account of Mustafa Gadala, a quote unquote black
No,
man from,
Mustafa Hefni.
Mustafa
Mustafa Hefni.
Hefni. Gadala is the scholar. I was just citing him the other day. Mustafa Hefni from Egypt. And he tried to get an SBA loan, and they told him that you can't just waltz in from Africa claiming to be black. Sorry, sir, you're white. It's like, what? You see my skin is black. Well, we know nobody, but this is what this guy is saying at the time. Anyway, they said that includes, and this is talking about the white category, those of Welsh, Norwegian, Greek, Italian, Moroccan, Lebanese, Turkish, or Iranian descent. Basically, how does Moroccans, Lebanese, Turkish, and Iranian people get to be classified by the, let's use the ancient term or the antiquated term, Caucasian? That makes no sense. Gorsuch nails this. It embraces an Iraqi or Ukrainian refugee, right? These two people that look completely phenotypically different. He says it embraces an Iraqi or Ukrainian refugee as much as a member of the British royal family. Oh, now let's get into this black thing. For all you that want to deal with the term Negro and call it black reparations, etc. Meanwhile, black or African American, and those of you who want to fight for African American, and those of you who fought us for African American, took Freedmen off your profiles. Took Freedmen off your profile. Let's see what he says about that. He says, meanwhile, black or African American covers everyone from a descendant of enslaved persons who grew up poor in the rural South to a first-generation child of a wealthy Nigerian immigrant to a black identifying applicant with multiracial ancestry whose family lives in a typical American suburb. Come on now. Come on.
Yeah.
Josh, Ali, what's
now,
going on here?
We remember our little brother, Booby.
That's
I'll
right.
call him that.
That's
our
right.
little brother, Booby.
We hope you listening, Booby. We hope you
came
listen.
came into the Twitter space and he tried to tell us, hey, listen, man, this is not right what you guys are doing. Y'all trying to give away our blackness to everybody else, man. I don't know if y'all know that that's what y'all are doing, but this is what you all are trying to do. And black is not a race. Well, I said, well, my dear brother is in denial, right? He's in denial because the history shows that these terms that came out of the British lexicon and the Latin lexicon, these terminologies were always used in this country as racial classifications, even outside of the color, the color connotations of this of these words, right? Because they were used as to describe colors, because Negro and black are actually terminologies used to describe colors. But in terms of their application to us as a people and as a group, right, as a racial group, they were absolutely used as racial classifications. And for those who, for whatever the odd reason, think that there's some difference between black and Negro, I don't care how Europeans use them, and they may have used it sometimes for Native Americans and this and that, I don't care. For those who think that there's a difference between the implications of these words from a color perspective, you're bugging, B. You're bugging.
That's right.
Josh, black is a Germanic. Black is a Germanic terminology, English origin, right? English is a Germanic language. Negro is of Latin origin. So for all of you who want to speak Latin and call yourselves Negro, that's fine. And for the rest of those who speak English and want to use the English word black, that's fine. You can do what you want, right? If you speak Arabic and you want to call yourself black, call yourself Sud or Sudan, that's on you, right? The point of it is that none of those terminologies, none of those terminologies are going to work for this reparative justice situation, because we see where this thing has gone just with this affirmative action piece today. But go ahead.
Yeah, Josh, jump in, bro. What are your thoughts on? Oh, man, this Gorsuch really breaks down, and I'm gonna finish reading, but I want y'all to jump in on this, and then we're gonna start, because there's so much that we obviously can't get to all of it, but we wanted to touch on the main parts, and these for us are a few of the main parts. Go ahead, Josh.
Well, I came on a little bit after, and I'm not sure if you brought up our letter that we actually sent to them.
Yep,
Did you?
yep.
Okay, you brought up and talked about.
Yeah, early on.
Yeah, man. When you read through, obviously, I know you didn't have time to read through that entire letter, but as I'm reading through this, I'm seeing parts. I'm like, oh, okay, that was in the letter. That was in the letter. We touched on that. We touched on that.
That's right.
And I was like, man, did they? I know we sent it to them. I hand delivered it over there, and so I know certain people received it, and I just don't know how it circulated, but it sure looked like it was circulating. It sure looked like it was circulating.
Hey, Josh, I was getting coming to the same conclusion. I wonder if they read our letter. I'm sorry. They wasn't even talking about this during the oral arguments, bro.
No. They definitely. Look, I'm
definitely, but I
no, somebody got it. No, somebody. No, for real. No, somebody had eyes on it.
The people we emailed read the letter.
No, I'm talking about
the justice.
Certain clerks or certain justices received the letter, and we start. You look at what's coming in this decision, and you look at what was not a part of the oral arguments. I'm not trying to take away from their, study and whatever the case may be, other factors they may not have gotten a chance to express in the oral arguments. But either one or two things: either we just prophets or something like that. We just knew exactly what they were going to say, or we were just really smart or well studied, or somebody got some insight from what we shared, and I don't think that's a far-fetched idea, but I gotta point that out, man, that with a lot of what we've been talking about and a lot of what we put and documented and expressed to them is actually in this decision. So and when you look at the decision, what you got to understand is it's not like a flat thing, right? It's like they agree with certain parts of the argument of one side, and they disagree with certain parts of the arguments of one side. So our main concern with this, right? Because we're so used to looking at things from the standpoint of, okay, we're black and we have racist whites, and we know the racist whites are going to have an opinion that's against us, and it's just that plain and simple. And what you see here is it's not that simple. You have to have a more nuanced understanding, and it's helpful to understand like Supreme Court cases and precedents and legislative history and all that kind of stuff. But if you understand that this America has allowed, and certain Congress, certain administrations, certain rulings have allowed the original. I don't want to say the original intent, but hey, man, it is what it is. The original intent of the spirit of the legislation and rulings and policy that was put in place that was supposed to help us, that was coming from the energy that we put in there. In the 60s, people were in the streets. People were getting killed, and not just in the South, in the North too. People were rioting. They were raising hell to get stuff changed, and that all of that culminated in people, like it or not, they had their criticisms of it or whatever. But the civil rights acts that came from that, that was a significant stride in the country for our people and for everybody that got the benefit. However, when we look at it today, we see that we're getting the low end of the short end of the stick, I should say. We're not getting the majority of benefit, although we suffered all the hells and we put in all the work to get the laws passed. So when we see that some of this stuff is being rolled back, hey, maybe we're looking at it like some of this stuff needs to be rolled back if it's not getting the intended benefit, if it's not serving to remedy some of the past injustices and discrimination, segregation, etc., to fix the position of the freedmen. Else get to eat, come step over top of us and get a disproportionate benefit, then that needs to come to an end. We can't be. I'm not too mad about that. So if that's the position that they're taking, hey, we agree.
That's right. That's right. So let me read through this, and we're gonna close this out, and we are gonna do a part 2. If anything attempts to divide us all up into a handful of groups, if anything attempts to divide us all up into a handful of groups, have become only more incoherent with time. Well, that's what America did. I mean, I got a book called White by Law, and the Supreme Court attempted to codify Blumenbach's 5 divisions of man. And if you look at the racial classifications in this country, in 1972, they used 5 divisions of man, if you will, in identifying who's who. But anyway, American families have become increasingly multicultural, a fact that has led to unseemly disputes about whether someone is really a member of a certain racial or ethnic group. There are decisions denying Hispanic status to someone of Italian, Argentine descent. Interesting choice of words. As well as someone with one Mexican grandparent. Yet there are also decisions granting Hispanic status to a Sephardic Jew whose ancestors fled Spain centuries ago, and bestowing a sort of Hispanic status on a person with one Cuban grandparent. Given all this, is it any surprise that members of certain groups sometimes try to conceal their race or ethnicity? That line is so powerful, family. That's a powerful line because we have people cosplaying as quote unquote African American Black people today because of this federal directive 15 that Gorsuch calls a piece of bureaucratic nonsense, basically. I'm adding the word nonsense, but that's technically what it is. Or that a cottage industry has sprung up to help college applicants do so. We are told, for example, that one effect of lumping so many people of so many disparate backgrounds into the Asian category is that many colleges consider Asians to be overrepresented in their admissions pools. Brief for Asian American well, that's the source. Paid advisors, in turn, tell high school students of Asian descent to downplay their heritage to maximize their odds of admission. What does that bring to mind? Anybody? What does that bring to mind? My man, that the Hindu guy that shaved his head bald and got admitted to a college as an African American. The Hindu guy, I can't think of his name. I think his sister name is Mindy something. Paid advisors in turn tell high school students of Asian descent, this guy, according to this convoluted Federal Directive 15 racial classification that's not based on science or anthropology, got admitted into college by cosplaying as an African American. And the quote is, "We will make them appear less Asian when they apply," one promises. If you're given an option, don't attach a photograph to your application, another instruction. Now, we're trying to get in college. They're passing over us and selecting Black immigrants. And y'all know that we read from a paper. I read from it last night in my debate with Randy Perham. It is difficult to imagine those who receive this advice would find comfort in a bald and mistaken assurance that, quote, race-conscious admission benefit the Asian community, the Asian American community, right? So, I mean, I could get a little bit deeper into Mandy Kaling's brother. Thank you.
Can I say one more thing, Brother
Yeah,
Naheem? Because I didn't want the message to be twisted or whatever. But we know the reason why the Asian groups are fighting for this, and the reason why really it's like a lot of the racist whites are behind them, right? And it's because they see affirmative action as a historical win for the freedmen back in the day, and they're neo-Confederates, and they want to roll some of that back, even though we're not getting the majority of the benefit. And as far as the Asian groups, that are pushing this, they obviously stand to benefit with removing the impediment to allowing them to overrepresent and have it, and the enrollments is into some of these schools, because, and this is not a knock on anybody. I mean, obviously, if you having high achievement in education, that's to be commended. However, we have to understand that it's because they always try to use the minority tropes and say it's the dude yesterday was talking about it's a culture issue. No, really, it's a fact that you have a nation. A lot of people are coming from nations that have huge populations, and a lot of these huge populations, you have that many more people that come from a ideal background where you have had access to top quality education or whatever the case may be, stable families, up elevated economic and social status. So now you are coming to America, and this is not everybody, but this is a disproportionately large number, that you're in a better position. So you get to cherry pick the people that are more likely to do well and bring them to America. And so then you have a large number of those people. And yeah, obviously they're gonna be, because they're overrepresented compared to their population in their home country. Those people are overrepresented here, and now they're getting to access certain opportunities that should be set aside for freedmen, in terms that the government needs to fix the damage that it did generationally by allowing us to they have to create the disproportionate access to remedy that past discrimination, et cetera, et cetera. So we understand that this being rolled back, this affirmative action stuff being rolled back, or they cleared up, or whatever, however you want to frame it, is not going to necessarily be in that respect a benefit to us. It's just gonna open up the door for more people that are already overrepresented in those college populations, and and that's probably going to have further application there across the board. However, each situation was a losing situation. So I'm looking at this as, at least now they're stopping one problem that we can, and they're giving us a way for us to actually get to the bottom, to get back to the original intent. If we can get new legislation passed, that's going to be up to us now. Go ahead, Brother Naheem. Are you on mute, bro?
My bad. That's a fact, bro. That is a fact. So, man, when you look at how we did our submission to the OMB, our recommendation, one of the things that we obviously advocated for was usage of the term American freedmen as its own ethnic designation. This court case just gave, this holding from the Supreme Court just gave our push, just gave the merits that we stand on a big boost. Huge boost. We also advocated that the racial classification of Black, although I would rather all of those classifications be done away with, be changed to reflect proper language that's in alignment with the other classifications, because it's not. But the other one was to change the term race to population group. This gets us out of this racial language. This gets us out of this racial language. Now, I don't know, and it's hard for us to know if in doing that, it doesn't trigger strict scrutiny in some way, because it may still do that. But the fact that that loaded term race is there sure wouldn't help or excuse me, hurt our chances if this thing is replaced as we move on in the future. But our our recommendations is based, I mean, our fight, excuse me, I'm trying to read and all of that at the same time, is based on the status of the American freedmen. It's not based on race or even using the term population group. This court case, this holding from the Supreme Court again gives what we are fighting for over here at Be the Power and the United Sons and Daughters of Freedmen a boost. Now, either they've been reading our stuff and following us, or family, we've been on point from day one. Somebody called us them smart, authentic brothers a few years ago, and we've been proving that every single day. And I want to bring people to our website because I want to round our conversation off with this, right? So this is from our website, who is eligible for reparations. And we have a section called the Freedmen Criteria. So I want to read that real quick. It says, the Office of Management and Budget issues a disclaimer in its Statistical Policy Directive number 15, that thing that Gorsuch was just referring to, with regard to the racial classifications. It states that, quote, these classifications should not be interpreted as being scientific or anthropological in nature, nor should they be viewed as determinants of eligibility for participation in any federal program, end quote. The United Sons and Daughters of Freedmen are developing a criteria that will include science and or anthropology in conjunction with descent from at least one emancipated ancestor in the United States. Y'all stay tuned for that, because it's going to be dope when we finally develop the criteria that we will be pushing from here on out at Be the Power and the United Sons and Daughters of Freedmen. So I wanted to share that with the family, and I want to share with you all my thanks and gratitude for all of you that are listening in, for all of you who have supported. Thank you all for the contributions you've made to the channel. I try not to call people's names out because they may support other channels, and we've seen people from other channels get puerile and childish and petulant and cut people off, even if they give them money, which is weird because it seems like that's what they're in it for, just because they rock with us. So I try not to call certain people's names out other than those who send contributions through the super chat, because I mean, it's clear, you can see that. Shout out to you all. And again, if you want to support the platform, the Cash App is pinned to the live chat, $ Be the Power. We gave a masterclass tonight. There will be no breakdown. There will be no breakdown like this one, because this one deals with us as American freedmen and how we as American freedmen tie into the status of freedmen and tie into that Reconstruction legislation that undergirds our status. You will not see another breakdown like this. Oh, excuse me. Until we do part 2. Josh, you have anything to share before we start winding this thing down and wrapping it up?
Man. Excellent program. I can't wait to go back in on the next
Oh
go
yeah.
round.
Oh yeah. I can't wait to listen to this one again. You know, there was so much that we did not cover. There was a lot that we did not cover. And I can tell the people that read the, this very long, long. I focused on key things. Obviously did not read the whole thing, but I read good portions of it. Good portions of it.
Yeah, all three of us.
That's right. That's right. So yeah, thank you all for tuning in. This has been validation. This has been validation. From the first time the oral arguments were heard to the Second Amendment court case, where it's almost seemed inexplicably Justice Thomas invoked the status of the freedmen. I was like, why? I didn't understand it. And in some ways, I still don't understand it. But he did. That providence. We have people telling us that the Supreme Court case over the Child Indian Welfare Act might be detrimental if they rule against those Native American families. Might be detrimental. So we shouldn't use American freedmen. We shouldn't use it. We should not use it. Oh man,
Brother
y'all gonna
Naheem,
pull that up. Uh-huh.
I did want to say one more thing.
Go ahead,
So,
bro.
for this, I mean, just read this and understand. If anybody that's currently involved in any reparations, work, where you're gonna be deciding on or voting on eligibility or terms you're gonna use or all this kind of stuff, you really and administer certain programs or whatever that you're gonna recommend. You really need to understand that if any of this ever comes to fruition, because a lot of times people think it's pie in the sky, we can just do whatever we want and say whatever we want. Yeah, but when real life has to be faced, and you actually, I mean, you actually live your dream, right, of actually getting it voted on in your city or state or whatever, and now it's actually going into to be law. This thing is going to be challenged. It's going to be plenty. It's too many people that hate us historically. There's too many people that knew over here that want to make sure we stay at the bottom. People are going to push to try to challenge this thing, like just like it challenges affirmative action stuff. And if you if you understand how the game is played, why would you go against the rules? Why would you add an additional incline to an already uphill battle? I don't understand why you would want to do that. So this needs to be a lesson learned. If you are a part of any type of advocacy, or if you have any proximity to influencing anything on any legislation, especially any reparations proposals or anything like that, you got to understand the impact of this decision. And it's not something that we didn't already express. So, hey, that's it's particularly, I want to say, like, for those people dealing with reparations, working in reparations, whether on the state, local, whatever, you got to understand the impact of this thing. Otherwise, you can expect to get a similar ruling, and it's not going to be looking good.
Indeed. I was trying to pull it up, Ali. I'm hitting the paywall from the New York Times. I wanted to read where Kavanaugh said that freedman was a status. I wanted to read that it wasn't a racial term, that it was a status term. But I hit a paywall. But we drove our points home tonight, You know, Charlie Jacobs said, I think this breakdown will unite some of the other reparationist scholars. And I hope so. I hope so. Sister Roz said, this is a podcast to put on rewind. And I'm going to listen to it again. I'll listen to all of them again. But this one I'm going to really, really listen to. This thing is moving, family. And we are helping to move it. Like, there was this piece I wanted to bring up from Eric Foner. Oh, where was it? Sheesh. The highlighted part is going. All right, never mind. But I wanted to bring this piece up from Eric Foner and what he said about the freedmen. Let me see.
I got the Kavanaugh piece because I got the.
Yeah, go ahead. Read. Go ahead.
All right. So it says here, during oral arguments for the biggest Supreme Court cases, the justices' questions are often pointed, meant to advance their own view on the case. Conservative justices ask friendly questions of lawyers on the conservative side and burrow into the logical weaknesses on the liberal side. Liberal justices do the opposite. So it says the 5 hours of oral arguments on 2 affirmative action cases in October mostly fit this pattern. But about 3 hours into the session, Justice Brett Kavanaugh asked a less typical question. It involved slavery, and it raised an inconvenient issue for Kavanaugh's fellow conservatives. Quote, so today, a benefit to the descendants of slaves would not be race-based, correct? Unquote. Kavanaugh said to Cameron Norris, a lawyer arguing for the end of race-based affirmative action. Norris seemed caught off guard.
Yeah, you went out, Josh.
Okay. When I'm doing it on my phone, if I navigate away from the screen, it cut me off. What was the last thing you heard?
Race-based. It was a question.
All right. Okay. So it says, so today, the benefit to the descendants of slaves would not be race-based, correct? And then Norris was caught off guard. He said, I think that's incorrect, Justice Kavanaugh. And then Kavanaugh then noted that Norris had already acknowledged that the post-Civil War benefits that formerly enslaved people received from the federal government were not race-based. Those benefits were based on their status as having been enslaved, not their skin color. And so it continues, it says, if that's correct, then the benefit for descendants of former slaves is also not race-based, Kavanaugh said. You can make other arguments if you want about that, but it does not seem to be race-based. So, you know, in that oral argument, he made the Freedman case right there. I mean, we talked about this for a while, you know, last year. And guess what? You know, yeah, well, I'm not going to say too much else on that, but they received, you know, the Freedman concurrence from the Freedman letter from the United Sons and Daughters of Freedmen. They received that. So we'll see how else we want to build on this tomorrow. Did you have something else you want to share?
Yeah, I'm gonna do one more thing. I want to read this because I want to leave us thinking about remedy. I want us to take into consideration everything that was said, read from this Supreme Court holding, and I want us to leave thinking about remedy. So I want to read from an article from Eric Foner. Real brief. I don't know, my computer is having issues right now, and it's trying to save the highlighted version of the PDF. Can you see the screen, Josh?
No.
All right. I'm having some problems right now. All right, so I can't even read it. My whole computer.
If you send it to me,
it's crazy. I can't do.
You send it to me, I can read it. Oh, damn.
Yeah, I can't do nothing right now.
It's from the second founding.
Yeah, no. I don't think so. I don't think this is from the second founding. Something is wrong with my. I'm trying to save.
Oh well, it's just the Josh show tonight, I guess. But hey, I think that's a wrap, y'all. It's been a great program. We're gonna go ahead and close it on out. We gonna come back, I think tomorrow and follow up because there's so much more we didn't get a chance to touch on. And I wish I had the outro to play, y'all, but I'm just gonna quote my brother Logic and say, government is the game and politics is how the game's played. And with that, I say back to Naheem. I was just about to close out.
All right, look, because I know I don't want to belabor this thing. We went in, but I want to leave us thinking about remedy, because in Foner's book, the second founding, he speaks about he's baffled that while today's civil rights leaders and activists do not use the 13th and 14th Amendment in their remedy. That's because they don't know. They're following behind liberals, and we see how the liberals badly construed what they called race-conscious legislation and how they got washed by the other justices. So I want to read this. The Warren Court ended the practice of citing Bowers and other Dunning School authors. Dunning was a racist, and y'all just look up the Dunning School as I want to get through this. Decisions of the 1960s refer to a few key revisionist books, notably Kenneth Stamp's The Era of Reconstruction, W.R. Brock's An American Crisis, Eric McKittrick's Andrew Johnson in Reconstruction, and C. Van Woodward's The Strange Career of Jim Crow. These were revisionist works. With them came a revised view of Reconstruction. For example, in United States versus Price, the case arising from the murder of 3 civil rights workers in Mississippi in 1964, the Supreme Court cited Stamp to demonstrate the point, long ignored by the court, that the main purpose of the 14th Amendment had been to protect the rights of the freedmen. I may have said something wrong. I think those authors' works reversed the Dunning and Bowers school. So that court cited that the main part was to protect the right of the freedmen. It says perhaps the most extensive invocation of historical scholarship in the 1960s came in, this is a case you hear us all cite, Jones v. Alfred H. Meyer Company, in which a 7-2 majority allowed suits for damages under the Civil Rights Act of 1866 for racial discrimination in the sale of homes. We know the history shows that this particular case undid about 100 years of legal segregation that began with the 1883 civil rights cases. It continues. Members of the court cited an array of revisionist works, including Stamp, Brock, and others, even an extremely unusual move, Du Bois' Black Reconstruction, to offer an expansive reinterpretation of the purposes of Reconstruction legislation. Like John Marshall Harlan decades earlier, the majority in Jones described the Civil Rights Act and 13th Amendment as efforts to give a real content to the freedom brought about by the Civil War. The dissenters were similarly familiar with new scholarship. Yeah, I'm right. The scholarship was in reversing the revisionist history of Dunning. They drew upon Leon Litwack's North of Slavery and an account of the deep racism in the pre-Civil War North in an attempt to demonstrate that Congress could never have intended to promote racial equality in the sweeping manner claimed by the majority. Again, it all goes back to status. It all goes, I'm going to put that link in the chat. It all goes back to the fact that our remedy is in the Reconstruction Amendment. Point blank, period. Point blank, period. We got a troll in the chat. Of course, we got a troll. Somebody had to come in here and say something like, man, they cooking. I got to try to do something to disrupt them. But we will pay the troll no mind. We will let the troll just do what trolls do. So with that, family, thank you all, man, for tuning in. I'll leave you all with the motto of the platform, which is don't just fight the power, become the power. And then and only then will you have the power to make a change. With that, I say peace.